I see your Lordship's indulgence, Your Lordship, from part 2, if I may be allowed to mention, item 3 and 4, Your Lordship, if these can come up next week. Also, items 7 and 9.
From part 2?
Yes, 3, 4, 7, and 9.
All right.
Next coming week. Yeah. Thank
3, 4.
7 and 9. I'm obliged.
Lordship, may I seek your indulgence in mentioning item number 6? May the matter be taken up this Thursday. Part 2.
Item number 6.
Yes, Lordship.
Thursday or
Yes.
next Monday?
Yeah, next Monday.
Huh? Yes, I will be leaving on Thursday. So next Monday
Yes, Lordship.
or Wednesday? Not Wednesday.
No.
Hearing
Wednesday
day.
evening,
Okay,
yeah.
next Monday.
Yes, Lordship.
Learned
Lordship,
Council.
item number 11 and 12. May the matter be taken up
This is
after 2 weeks.
earlier you have asked for item number 6.
Yes.
Learned
And this is
Council.
for item
You are
11
for?
12. For item 6, I'm for the respondent.
Oh, item 6 for the respondent.
Yes, Lordship.
You are PP?
Huh?
You are the PP or
No.
respondent number 2?
Respondent number 1 to 5.
Item number
Private
6?
Respondent.
Part
Yes,
2?
Lordship. Yes, part
Oh,
2.
part 2. Okay. All right, yes. Item 6, part 2, yes.
And Lordship, item 11 and 12 of part 2. After 2 weeks, Lordship.
Yes, after 2 weeks. Who will note it down? You or?
Daily list for motion, item number 1.
I praise your Lordship. Lordship, this is a petition regarding releasing of a seized vehicle, which was seized by DRI in connection with the DRI case on 23/4/2024, your Lordship.
Long time back. What was the last order?
Your Lordship, last order was,
Motion, no order was passed.
yes, annexer, I annex it on page
Seized in
15.
connection with NDPS Act. We have the PP here. So we'll call for a report. Investigation is going on.
Actually, yes, your Lordship, actually this is DRI, the Director of Revenue Intelligence.
Oh yes, I understand. So,
So state is not a party, your Lordship.
Standing council is there.
Standing Council, of course.
Yes, Lordship, I'm a standing counsel for the DRI, Lordship.
Okay.
I'll accept notice on behalf of the department at this stage.
Let us call for a report then
Yes, Lordship.
relating to the vehicle seized in connection with this case.
Lordship.
Learned Counsel Mr. Anish Borbuya is present on behalf of the petitioner, and Learned Standing Counsel for the DRI Mr.
Johnny L. Tochong.
Johnny is present for the is present, not for the is present. Call for a report relating to the vehicle bearing registration number
S11 DC 4048.
a truck seized in connection with this case.
02 CL IMP oblique NDPS hyphen maths oblique DRI hyphen.
You note it down, it's there in the cause list. Oh, sorry, not in the cause list, in the, I think, first paragraph, case number. List the matter of, I'll give a date or a week's time.
After a week, Lordship.
Next week it may be.
List the matter after 1 week.
Lordship.
Nice.
Item number 2.
May it please, Your Lordship? Lordship, the petitioners numbering 3 are aggrieved by the action of the respondent number 1 and 5, that is the railways, who have illegally encroached upon their lands for construction of the railway project from Bairabi to Sairang. In fact, Your Lordship, before the encroachment was done, the railways had taken steps under the Railways Act 1989 for acquiring the land belonging to the adjacent landowners. Even an award was made by the collector, competent authority, and the land of the petitioners was not included in the award. But in spite of that, their land has been encroached upon.
Yes, yes.
And so there's a clear violation
Acquired
of,
or encroached?
pardon,
Land has been acquired or encroached?
has been encroached without acquiring the land. So there's a clear violation of Article 300A, Your Worship. And we had submitted our complaint to the DC. And if I may take Your Lordship to page 44.
So, but this is a case under this railway construction, relating to railway
Yes.
construction. So, I think interim stay is not warranted in such
Yes,
type
Your
of
Worship, because
cases.
the work is already completed.
Work is about to be completed.
90% complete.
So, let us hear both the sides. Will issue notice.
Notice will go.
Learned counsel for the petitioner, Mr. Malhotra is present. Learned government advocate.
No,
For railways
for
advocate.
respondent number 1 and 5.
Railways.
Yes, my lord.
You're for the railways. Learned counsel, Miss.
Baby Ladin Zwali.
Standing counsel or PP?
On
what
behalf
is
of
the-
my senior Central Government Council.
is present on behalf of
CGC.
CGC. Okay, CGC.
Yes, my lord, I represent the state,
Mr. Who is the
state
CGC?
government for the
Zairem Sangui. The name of the CGC is
Oh,
Zairem
Zairem
Sangui.
Zairem Sangui is present on Learned Council Miss So is present on behalf of the CGC, Miss Zairem Sangui, for respondent number 1 and 5. Learned government advocate, Miss,
Vade Siamia,
is present for the respondent number 2, 3, and 4.
2, 3, and 4.
So notices have been issued. So we will, everybody is present.
Everybody is present.
List this matter for admission then.
Yes. No, Your Worship, notice may, Your Worship may kindly say notice issue notice to the respondents.
Okay.
As they are represented, no formal notice is required. And
As the respondents are represented, no formal notice is required to be issued, and learned counsel for the respondents have accepted notice on behalf of the respondents.
yes, this after 2
However,
weeks.
sufficient copies to be furnished during the course of the day. List the matter for admission
After 3 weeks.
after 3 weeks.
For orders, item numbers 3 and 4.
May it please Your Worship. In fact, in item 3, 4, and 5, we have received the paper book. So the matter may kindly be fixed for hearing on 25th of November.
For paper book.
We have received the paper book.
Sorry, what?
We have received the paper
Oh, you have
books.
received a paper book.
So the matter may, all the 3 matters may be fixed on 25th of November for hearing.
Okay. 25th of November is a Sunday, I believe.
20, sorry.
Oh, no, Monday.
Monday.
3, 4, and 5.
Yes, Your-
Learned counsel for the appellant, Mr. A.R. Malhotra has submitted that the appellants have received that he has received the paper book. Learned, no, these are not relating to POSCO or anything.
No.
No. So we don't want
PC
a
Act.
respondent number 2.
Yes.
PC Act.
PC.
Act.
Learned government advocate. Learned PP.
Yes, additional public
Learned additional
prosecutor.
PP. Miss So and what is your name?
Vane Siamia.
So and so is present. List this matter for admit. Will admit it statutory
Yes.
appeal. Admit. List this matter for hearing after how many?
No, 25th of November.
On 25th. We'll give a date.
Yes, Your-
Okay.
25th.
On
No,
25th of November.
I'm okay.
Item number 6.
May I praise your lordship. Lordship, in this case also, we have received the paper book. Say it may be fixed on 13th of December because one advocate from principal bench has to attend the case.
13th of December.
So he requested me to fix it on 13th of December.
Learned counsel Mr. A.R. Bhuya is present on behalf of the applicant. Learned additional PP Miss So and so is present for the respondent state. Paper book is ready.
Yes, your lordship.
Paper book is ready and has been furnished to the parties.
Yes,
Everybody has
my lord, we
received the
have
paper
received
book. List the matter for hearing on December what?
13, 1-3.
December.
Nice.
Item number 7.
Lordship, I'm for the appellant,
For the appellant. Criminal appeal.
No, Your
Their
Lordship,
last
this
order,
is,
no? You write only one word, admit last order. Yes.
yes, this is a civil appeal, Your Lordship. This is an application for condonation of,
Oh, no. This
Yes.
that will be for admission. That was a civil appeal, last order. It's a civil appeal, no? It will be listed for admission, not hearing. Oh, hearing. Last one was civil or criminal? Oh, this is civil.
this is civil.
Okay. Then last one you write, item number 6. Last one you write, admit. Then you fix it for hearing on 13 December. Yes.
Yes, Your Lordship, as per the last court order, notice in respect of the respondent number 3 has been awaited. So this morning I have not checked it whether. So in the meantime, Your Lordship,
8/11/2024.
Yes.
No, respondent number 3 has not received notice. So we'll fix it for when? After 2 weeks?
2 weeks. So we are still waiting for. That means we have to wait for the notice.
Yeah.
Yes, 2 weeks.
Or you
back.
want to take fresh steps? Do you want to take fresh
Or we can do it if I may be allowed to do it by dusty service.
Office note dated 18/11/2024 indicates that service report on respondent number 2 is awaited. The appellant may take fresh steps to issue notice to the respondent number 3 returnable within 3 weeks.
Yes. Yes.
Justice service is also permitted. List the matter accordingly.
Thank you.
Item number 8.
In the usual course. Not process.
May I please your lordship? My lord, this is an application for impleadment of Mr. Ropung Atsungte. He is the one who purchased the landed disputed property during the pendency of civil suit of 2009. So, my lord, he's a necessary party because he's now the owner of the land.
So, you know, no, here there's a notification circulated that you have to file one application, I think, for impleadment.
Yes, my lord.
That notification was, I think, last year notification has been circulated. for implement, for amendment of cause list, any type of orders, one application has to be interlocutory application has to be submitted. I think so. Have you?
My,
Okay. Oh, you have already submitted.
yes, my lord.
Yes. Carry on.
Yes, my lord. He is a necessary party because he is now the owner of the landed property, and without his presence, it will be improper to proceed the case.
Do you have any objection?
No, my lord, we don't have any objection.
He is the owner of the
Landed
property in dispute.
yes, my lord.
Learned counsel Miss
Ruth Larwat Feli.
is present on behalf of the applicant in the IA, huh?
Yes, my lord. I
Learned counsel Miss
Emily L. Sangte.
is present for the respondent opposite party number 1. And what about 3, 4, and 5? They are not present. State is present. State is present. Learned counsel Miss Linda is present on behalf of respondent number. It will be 3, 4, 5, and 6. This application has been filed with prayer for implement of Mr. Rokunga Chungte, na?
yes, my lord.
Rokunga Chungte.
My lord, we are for respondent number 1 and 2.
Respondent number 1, yeah. I have referred to you to be as respondent number 1,
Yes, my lord.
isn't it?
1 and 2.
1 and 2. You are for 1 and 2.
Yes, my lord.
To arraign, not imprisonment, with prayer to arraign a RRA IGN, Mr. Rokunga Chungte as a necessary party, as he has purchased the land which is in dispute in connection with this case.
Yes, my lord.
Which is the original case?
RFA 6 of 2016.
Number? Case number?
6 RFS 6 of 2016.
This appeal is against a judgment and order of civil judge.
Yes, my lord.
So that, what is the number of that case?
Civil suit number 2 of 2009.
Please write down this number. An appeal has been preferred against the judgment and order of the aforementioned case, which is registered as RFA number 6 of 2016. The learned counsel for the respondents have no objection. Mr. Rokunga Chungte may be arraigned as respondent in connection with RFA number 6 of 2016.
16.
Applicant to file an amended cost title. You'll have
Yes,
to
my
file
lord.
an amended cost title, no, now.
Yes, my
You
lord.
cannot just note down the name like earlier.
We have to file the
You'll
amended
have
cost
to,
title.
yes, may file an amended cost title in terms of the above order. In terms of the above observation, this application stands disposed of.
Obliged.
Oh, yes. List this RFA in RFA number 6 of 2016. List this matter. After 2 weeks? After 2 weeks? All right, after 2 weeks.
Item number 10.
May it please, Your Worship, the RFA is a regular first appeal against the impugned order dated 30th of October 2023, passed by the trial court in heirship certificate case number 1308 of 2023. And Your Worship, the IA is an application for condonation of 284 days. So your notice may go in the IA first,
IA noticed
sole respondent.
applicant to take steps to issue notice to the respondent through registered post with AD as well as through usual process. Returnable within 4 weeks, 2 weeks?
2 weeks.
2 weeks.
Steps within 2 days.
Steps to be taken within 2 days from today. List accordingly.
Hearing list, item number 1.
Same. Oh, this case.
Yes.
Okay, part of matter. Okay, I want to ask you a question. See that relating to issue being not framed to the compensation for damages on account of mental agony.
Yes.
Then he has stated that issue is not required to be framed. But there are judgments that if issue is not framed, then additional issue has to be framed, or there are judgments that it has to be remanded back to frame fresh issues.
Yes.
So this is one point I want to ask.
Yes.
Then relating to that, he has stated that part and parcel, prayer is the part and parcel of the pleadings. But you have replied that they have not led evidence.
Yes.
So, and then it was covered by another issue, any other relief.
Yes.
So what do you have to say on these 2 points, and do you have any judgment?
Yes. Your Worship, my humble submission at this stage is, Your Worship, instead of remanding the matter back for retrial, Your Worship may kindly come to a specific finding whether the quantum granted by the trial court regarding mental agony is based on the evidence.
It has been admitted that there is no evidence, but he has stated that it has surfaced through the evidence.
Yes.
But you have stated that there is no evidence that he has been running from pillar to post.
Yes.
Because only one order of the DC,
Yes.
then everything has been taken care of. So this is
Yes.
your submission.
Your Worship may pass necessary judgment here instead of remanding the matter again.
No, I won't remand.
Yes.
At this stage, what
Yes.
is the point of
I
remanding?
know.
But when issue is not framed, there are judgments that that issue has to be framed.
Yes.
So there are many judgments that
Your Worship, the matter was remanded by the trial court on one occasion.
I know. That is why I'm
Yes,
asking.
that-
So again, second time remanding and such a noble matter.
yes. And in the first remand, the trial court had directed the High Court had directed the trial court
Yes, it is there.
to give a finding regarding prayer in
17B
17B and 17D.
C.
D. Yes.
Finding on?
Damage.
In the remand order passed by this Honorable
Yes,
Court,
yes.
there was a specific direction to the trial court to give a finding regarding the relief claimed. So, but in spite of that, the trial court did not frame any issue. So anyway, Your Worship, that may be overlooked.
The reason being is that, Your Lordship, at page 205 of the paper book, where that issue number 7 is there, whether the plaintiff is entitled to relief claim.
That is what I was asking.
Yes, because the relief claim will naturally mean, in my humble opinion, the prayer portion, what has been mentioned in the prayer.
Okay, I'll note it down.
And Your Worship, relief has to be based on evidence. If there is no evidence,
That is also there.
That is also there.
unless there is no
See,
evidence,
there he has a point. That relief has to be based on evidence.
I understand.
And then he has correctly submitted that on one order of the DC, everything has been taken care of.
But then I was forced to come to the court, and I have to wait for 13 years. 13 years, Your Lordship, from 2011 till today.
Yes.
Why have I? The reason why I have been forced to go to the court is because of his actions, and that is something they have not denied.
And also, Your Lordship, the other day, I had made a mention regarding that there's a judgment of the apex court which says that if its amount given is not exorbitant, some guesswork can be
There is a judgment, I
Yes,
know.
because-
And according to the inflation and all.
correct.
But I don't have the judgment with me and I forgot absolutely.
I
forgot the
can
party's
provide
name.
it during the course of the day, Your Lordship. I'll
Yes,
give it to
yes.
the court master.
Absolutely forgot the party's name.
I can.
And that was when I was in the trial court as a trial judge. That I was the appellate judge as a district judge. I used to refer to the judgment, but now I have come, I'm taking up only criminal matters, so I forgot, absolutely forgot.
Because the reason why I'm saying is that because the amount of inflation was taken as 2,000 for a period from 2011 to 2021. That is 10 years gap.
No, there is a judgment.
Yes,
I know.
I'll
there is
provide-
not a judgment. I think there are 2-3 judgments.
There are quite a
relating
few,
to
Your Lordship.
That some prevailing circumstances can be taken into account. The increasing rate of inflation, the cost of prices can be taken into account to add to the compensation. There is a judgment, but I cannot remember.
Because 10 years would mean 2 pay commission, Your Lordship. In any event, Your Lordship, with Your Lordship's permission, I will hand it over to the court master
Yes,
during
yes.
the course of the day.
This dispute between the parties is only relating to the amount.
Yes,
So you have boiled down to only that portion.
yes, only that portion.
So others are not, anything is not disputed. And then you are emphasizing on this issue not being framed.
And lack of evidence.
And lack of evidence and mental pain and agony. Yeah.
Yes.
On that, Your Lordship, on that ground only, I'll provide the judgment. Otherwise, everything else.
Pure, even if there's a delay in disposal of the appeal, as of the case, there's no allegation made by the plaintiff that the delay was caused to the actions of the defendant. I mean, this is the second round. The matter
exactly.
had come up before the Honorable High Court, it went back.
Second round filed by
so
him.
there are no allegations against the defendant that the matter was delayed, disposal was delayed due to the delayed tactics on the behalf of the defendant. It's not the case, Your Worship.
In fact, Your Lordship, that property after the house was dismantled in 2011 has remained vacant. And upon receipt of that partial payment, which they have made as a condition for stay, I've recently started construction on that vacant land since last year.
So
Only.
he hasn't lost anything, that means.
No, I have lost. I have lost. I'm forced to dismantle my house. Let's not forget that. Due to his actions, which he has not denied also.
So just let me ask one personal question. What is the source of income of your client?
He's a businessman.
Big businessman. He has a farmhouse also, Your Lordship.
Even the
He has a farmhouse also, a very, very big
Even the
Gudam
plaintiff is quite
business.
well off. It's
I'm-
not that
I'm a
he-
pension-
He's
no,
not
no,
a
no.
pauper or something.
No. I am a pensioner from the health department. I used to be in that.
This is off record.
Yes.
Off record.
I'm just, it will
Yes.
be ingrained in my brain,
Yes.
but I won't.
He has a
comment on
farmhouse
that.
also. Your Lordship.
The plaintiff has a plot of property bang in the middle of Aizawl.
Which was never the case. No, we are talking about, Your Lordship, if I may. I mean, my learned friend can correct me on this. This particular property in 2011 used to be considered slightly outskirts of the city.
2011, yes.
Yes. But if we go today, the entire stretch of road is filled with houses left and right. So that is the only reason why he's saying bang in the middle.
I have seen this, I have noticed houses are very congested.
Right.
Buildings are constructed in a very congested manner.
It's
So that
space is a
scenic
premium. You know.
beauty is being
Earlier,
diminished in this manner.
early on, there was no town planning. You can build
Such
wherever
a
you want.
beautiful place, but so many buildings have
Come up.
come up and
problem
that
with
too
that-
in such a congested
We
manner.
started having all these building regulations only from 2012.
Okay.
That's the problem.
That is the
Before that, it was entirely unplanned.
But place is beautiful, but this house is suddenly sprouted up from all the sides.
Okay.
All right.
Deeply
I think
obliged.
tomorrow I'll list this for order tomorrow, and you can give me the judgment.
I'll give it during the
I
course
have
of it.
because you have already concluded your argument, so I have prepared the judgment.
Yes,
So
yes.
tomorrow I'll deliver the judgment.
I'm deeply obliged.
She's typing.
Okay.
Busy typing long judgment.
Item number 2.
So we'll list this for judgment tomorrow in the morning. And you get the judgment. Both the parties are ready?
Yes, my lord.
This is an appeal, criminal or civil?
Civil,
Second
RSA,
appeal.
second appeal.
Okay.
Lordship, on 23rd 11 2022, substantial question of law was formulated.
So just let me ask you, because I'm here for only 3-4 days. Then will you be able to conclude? And I also have to ask you questions after concluding. Will you be able to conclude? Because this is a second appeal, you see.
Yes.
Right.
I'm here for, and then if I go there without the record, it will be difficult.
Right.
So if you are able to conclude within today, then tomorrow, then I can ask you my question also tomorrow itself. But if you are able to conclude within these 2 days, day after tomorrow I have division bench, so I won't be available. So you just ponder over it. I think you must conclude between these 2 days.
Okay, my lord, let it be next week.
You won't be able to conclude.
Yes, it's very
Because
tricky.
it's evidence and all, you have to
Okay.
consider everything, even in the trial court. Regular first appeal records, true records has to be considered.
So no point taking up.
Yes.
Yeah. I hope
very
you,
late.
I hope you will come again and that time you can do it. This
On
time
the
you have
first
a
week,
hectic. Yeah.
On the first week. If it is on the first week, see, like today, this judgment has been concluded. Tomorrow I'll deliver
I
the
know.
order. If it is
You
on the
have to
first week,
complete it. Yeah.
But I have only 4 days with me,
I know.
and then third day also there will be division bench.
Yes.
Okay.
Fine.
Learned Counsel Mr. Eldrin is present on behalf of the appellant. Learned Counsel Ms. Dinari
Yes.
is present on behalf of respondent number 1. The others are not present, no?
They are pro forma only.
Okay. List this matter for hearing on the next week? After 1 week?
After 1 week. Let's
List
see.
this
Yes.
matter for hearing after 1 week.
Principal seat matters for hearing. Item number 1.
Our matters are over?